Hindu Marriage Act 1955 in bracket Hindu Marriage Act for short, close the bracket, sections 2, 5 and 7. Appellant is the wife, a Christian by faith, and respondent is the husband, a Hindu by faith. Marriage solemnized under section 7 of the Hindu Marriage Act. Validity of marriage under Hindu Marriage Act. Next para. Held. Next para. A. A reading of section 5 of the Hindu Marriage Act would make it clear that a marriage solemnized between two Hindus only could be a Hindu marriage. Such a marriage would be valid if the conditions mentioned under section 5 of the Hindu Marriage Act are fulfilled. Next, B. There are twin conditions which have to be complied with under section 5 of the Hindu Marriage Act. Firstly, two persons who seek solemnization of marriage under the provisions of the Hindu Marriage Act must and should be Hindus. It is not enough that one of them is a Hindu. Both parties ought to be Hindus. Secondly, there must be compliance with the conditions mentioned under section 5 of the Hindu Marriage Act so that there would be a valid Hindu marriage. On fulfilling the aforesaid conditions, a Hindu marriage could be solemnized in accordance with section 7 of the Hindu Marriage Act. Next para. Further held. Next para. A. In the instant case, admittedly, appellant is a Christian and respondent is a Hindu by faith. Therefore, they could not have got married under the provisions of the Hindu Marriage Act. Ex facie, there is non-compliance of section 5 of the Hindu Marriage Act, even though they may have undergone the ceremonies as per section 7 of the Hindu Marriage Act. In the instant case, the solemnization of the marriage between the two parties is not by two Hindus but by a Christian and by a Hindu. In the circumstances, there is no Hindu marriage performed between the two parties herein under the provisions of section 5 of the Hindu Marriage Act in the eye of law. Next para. B. Even if the parties had undergone ceremonies as stipulated under section 7 of the Hindu Marriage Act, nevertheless it cannot be termed as Hindu marriage as both parties are not Hindus. In the circumstances, the marriage solemnized between the parties is not a Hindu marriage in the eye of law. Next para. Hindu succession in bracket Karnataka Amendment Act, close the bracket, 1990, again open the bracket, Karnataka Act number 23 of 1994 with effect from 37/1994, close the bracket. Section 6A. Equal rights to daughter in co-parcenary property partition took place by virtue of two partition deeds dated 6/2/2003. Sale took place on 22/11/2004 by virtue of section 6 in bracket 5 of the Hindu Succession, open the bracket, Amendment, close the bracket, Act 2005, maintainability of suit filed by a daughter seeking rights in the co-parcenary property. Next para. Held. The state amendment of Karnataka had introduced section 6A, 6B and 6C to Hindu Succession Act with effect from 37/1994. The said amendment was in operation till the amendment to the Hindu Succession Act made by the Parliament, which came into effect on 9/9/2005. Thus, for the purpose of state of Karnataka, the daughters had equal rights in co-parcenary property even prior to the Parliament amending Section 6, which came into effect from 9/9/2005. Nevertheless, daughters married prior to the amendment were excluded from the co-parcenary rights. The said restriction is removed by the amendment passed by the Parliament. Next para. Further held. Next para A. In the instant case, the partitions took place by virtue of two partition deeds dated 6/2/2003. The sale took place on 22/11/2004. If respondent number 1 had no right over the properties in question by virtue of Karnataka Amendment, which came into effect on 37/1994, then on the ground that partition and sale took place prior to 9/9/2005, she would not get any right over the properties. But if she had a right over the properties due to Karnataka Amendment, which introduced Section 6A to Hindu Succession Act, which was in force till it was eclipsed by the central amendment, in that event she can maintain a suit for partition. Next para B. The decisions of the Honorable Supreme Court referred to by the petitioners considered those transactions in which the daughters had no right over the property prior to the amendment made by the Parliament came into force. By virtue of the said decisions, the daughters cannot prefer a suit for partition in the event if they had no right over the property prior to the amendment coming into force and the property was alienated prior to amendment coming into force. The above decisions of the Honorable Supreme Court do not bar the daughters from instituting a suit for partition if, as per prevailing law prior to amendment, she had a right over the property.